Why, hello there. We made it to Tuesday. I believe this is the last Tuesday of the month. Yes, it is. Now, I took the day off yesterday from recording because was President's Day, aka Biden's Day, aka Let's Go Brandon's Day. That's all I have to say about it. I did absolutely nothing but watch Netflix and chilled. But I came to work and noticed this hashtag over the weekend and at work, of course. And I wanted to know more about the Don't Say Gay hashtag on Twitter. And when I looked into it, I don't exactly understand it 100% to be honest. Other than you got the one side that's for parents' rights, and the other one is saying screw the parents, they don't need to know. And this bill is to address that. I think this bill was produced by Republicans, which says that the parents have the right to know. And then you get the left there are fighting this, saying no, the parents can't know. We are the educational service. We know what's best for the kids, and it's taking away parents' rights. Now, there's some arguments that do have merits, and I'll get to that later on. But first, I'm actually going to do something rare. I'm actually going to read a bill. It's only 5 pages, so don't be too impressed with me. But this is the Florida Senate CSCSHB 1557 Parental Rights in Education General Bill by Judiciary Committee, Education and Employment Committee. Harding, co-introducers Borio, Lavella, Maggard, and Snyder. Parental rights in education requires the district board to adopt procedures and that comports with certain provisions of the law to notify students' parents of specific information requires, such as procedures to reinforce the fundamental right of parents to make the decisions regarding the upbringing and control of their children, prohibit school districts from adopting procedures or students' support forms that prohibit school districts personnel from notifying the parents about specific information or that encourages students to withhold from a parent such information, prohibits school districts personnel from discouraging and prohibiting parents' notification and involvement in critical decisions affecting the school's mental, emotional, or physical well-being, prohibits classroom discussions about sexual orientation or gender identity in certain grade levels, requiring school districts to notify parents of health care services, authorize parents to bring actions against the school districts to obtain the declaration of judgment, provided an additional award or injunctive relief damages, reasonable attorney fees, and court costs for certain parents. Of course, there's been 16 amendments. Oh man, I got to reread these because they pretty much all failed except for Amendment 722367, remove lines 105 through 1010 and insert. And I am just going to pull this up because since this has actually been adopted and the others have been either failed or withdrawn, I want to see that. As of this, when I actually clicked on it, um, let's see here. Is there an update bill text? There's not. There's only of 217, so it hasn't exactly been adopted yet, according here. But this is as the bill, which is the C2 PDF, a bill to entitled an act relating to parental rights in education, amendments 1001 for 2 FS requiring district school boards to adopt procedures that comport with certain provisions of the law for notifying the students' parents of specific information. Yeah, English is hard, especially when you're reading out loud. Requiring such procedures to reinforce the fundamental right of parents to make decisions regarding the upbringing and control of their children in a specific manner, prohibiting the procedures from prohibiting a parent from accessing certain records, providing constructions, prohibiting a school district from adopting procedures or student support forms that prohibit school districts personnel from notifying their parents about specific information or that encourage or have the effect of encouraging a student to withhold from parents such information, prohibit school districts personnel from discouraging or prohibiting parental notification and involvement in critical decisions affecting a student's mental, emotional, or physical well being, providing the construction prohibiting classroom discussion about sexual orientation or gender identity. I have an issue with gender identity because I don't believe kids can be transgender. I'm sorry, you cannot be a trans light bulb. I won't recognize that if you're in school and under the age of 18. In certain grade levels or a specific manner requiring certain training developed or provided by the school districts to adhere to the standards established by the Department of Education, requiring school districts to notify parents or healthcare services and provide parents of the opportunity to consent or decline such services, providing a specific parental consent does not waive certain parental rights, which means if you waived it here and they came as gay, and you opted out of that, you still have, as a parent, a right to know that they're gay. Let's see here, parental rights requiring school districts to provide parents with certain questionnaires or health screening forms and obtain parental permissions before administering such questionnaires and forms, authorizing a parent to bring an action against a school district to obtain the declaration judgment that the school district procedures or practice violates a certain provision of law, providing for the additional award, injunction, relief, damages, and reasonable attorney fees, and the court costs a certain parental, requiring the department to review and update necessary specific materials by a certain date, providing an effective date. Be it enacted by the legislature, I cannot say that word, of the state of Florida. I don't know why I can never say legislature. It's just one of my quirks. Section 1, paragraph C is added. Subsection 8 of section 101.42 Florida status to read 1001.4 powers of duties of district school board. The district board acting as board shall exercise all powers and perform all duties listed below. Student welfare, an ordinance of the rights of the parental enumerated is SS 1002.2, and yeah, you get it. Adopting procedures for notifying the student's parents if there is a change in student services or monitoring related to the student's mental, emotional, or physical health or well-being, and the school's ability to provide a safe and supportive learning environment for the student. The procedure must reinforce the fundamental right of the parents to make the decision regarding the upbringing and control of their children by requiring the school district personnel to encourage a student to discuss issues related to his or her well-being with his or her parent and to facilitate discussions of the issue with the parent. The procedures may not prohibit parents from accessing any other student's education and health records created, maintained, or used by the school district as required by S 1002.22. Well, you get the point. School districts may not adapt procedures or students to support forms that prohibit the school district's personnel from notifying a parent about his or her student's mental, emotional, or physical health or well-being, or a change in related services or monitoring, or encourage to have the effect of encouraging a student to withhold from the parent such information. School district personnel may not discourage or prohibit parental notification of an involvement in critical decisions affecting the student's mental, emotional, or physical health or well-being. This subparagraph does not prohibit the school district from adopting procedures that permit school personnel to withhold such information if a parent, reasonably prudent person would believe that the disclosure would result in abuse, abandonment, or neglect, as those terms are defined as in S 3901. Classroom instructions, personnel, or third parties on sexual orientation or gender identity may not occur in kindergarten through grade 3. Actually, that should be grade 12, or in a manner that is not age appropriate in development, appropriate for students in accordance with the state standards. The reason why I say grade 12 is because kids cannot be transgender, and any parents that is encouraging or supporting this should be charged with child abuse. There's a gray area between 16 and 18. Willing to have that debate, but anything below 16 is a hard pass, and I will die on that hill. Student support services training developed or provided by school district to school district personnel must adhere to student services guidelines, standards, and framework establishment by the Department of Education. At the beginning of the school year, each school district shall notify the parents of each healthcare services offered at their student's school and the option to withhold consent or decline any specific service. Parental consent to a healthcare service does not waive the parent's rights to access his or her student's educational or health records or be notified about a change of his or her student services or monitoring as provided by this paragraph. I think we're on page 3, if not mistaken. Before administering the students being questioned or health screening inform students in kindergarten through grade 3, the school district must provide questionnaires or health screening from the parent to obtain the permission of the parent. The parent of a student may bring actions against the school district to obtain declaration judgment that the school district procedure or practice violates this paragraph and seeks injunction of relief. The court may award damages and shall award reasonable attorney fees and court costs to the parent who receives a declaration or injunction relief. By June 30th, 2023, the Department of Education shall review and update as necessary school counseling frameworks and standards of educational or educator practice and professional conduct principles and any other student services personnel guidelines, standards, or frameworks in accordance with the required of this act. Section 3, this shall take effect July 1st, 22. Oh no, we're actually done with the bill. Only took 13 minutes. Now here's the amendment that actually passed. Amendment number doesn't really matter. Representative Harding offered the following amendment to remove lines through 105 through 110 and insert each school district shall adopt procedures for parents to notify the principal or his or her designee regarding concerns under this paragraph at his or her student's school and the process to resolve those concerns within 7 calendar days after notification by the parent. At a minimum, the procedures must require that within 30 days after notification by parents that the concern remains unresolved, the school district may either resolve the concern or provide a statement of the reasons for not resolving the concern. If the concern is not resolved by the school district, a parent may request a commissioner of education to appoint a special magistrate who is a member of the Florida Bar in good standing and who has at least 5 years of experience in administrative law This special magistrate shall determine the facts related to the dispute over the school district procedure or practice and consider information of providing the school district render a recommendation, a decision to board a resolution to the State Board of Education within 30 days after receipt of the request by the parent. The Board of Education must approve or reject a recommendation or recommended decision at its next regularly scheduled meeting. That is more than 7 days of calendar and no more than 30 days after the date a recommended decision is transmitted. The cost of the special magistrate shall be borne by the school district. The School Board of Education shall adopt rules, including forms necessary to implement the subparagraph. Bring an action against the school district to obtain a declaration judgment that the school district procedure or practice violates this paragraph and seek injunction relief. A court may award damages and shall award a reasonable attorney fees and court costs to a parent who received a declaration of injunction relief. Each school district shall adopt policies and notify parents on the procedures required under the subparagraph. Nothing contained in the subparagraph shall be constructed as abridge or alter the rights of action or remedies in the equality of already existing the common law of general law. Removes lines 34 through 40 and inserts the questionnaires and forms requiring school districts to adopt certain procedures for resolving specific parental concerns, requiring the resolutions within a specific time frame, requiring the Commission of Education to appoint special magistrate for the unresolved concerns, providing requirements for the special magistrate, requiring the State Board of Education to approve or reject the special magistrate recommendations within a specific time frame, requiring school districts to bear the cost of a special magistrate, requiring the State Board of Education to adopt rules, providing the requirements for such rules, authorize a parent to bring action against the school districts to attain a declaratorial judgment that the school district procedures or practice violates a certain provision of law. Providing additional award of injunction relief, damages, and reasonable attorney fees and court costs for certain parents, requiring the school district to adopt policies and notify parents of certain rights, providing constructive requiring the. So that was the amendment that actually passed. Let's see here. Votes was 37 yeas, 75 nays. And of course the amendments which passed, which was the amendment that I read. So, all this to say that schools and school boards cannot, well, let's put it this way. As of, if this bill passes, the school boards, counselors that are at the schools must notify their parents of sexual orientation, of mental well-being. If they identify as a light bulb, they have to let their parents know that they identify as a light bulb and be able to make decisions on their own. If this doesn't pass and another bill gets passed, which will take away parents' rights to be notified or be part of the kids' decisions of making life-altering decisions. Now, I do understand why there's hesitance from a certain crowd that doesn't want this bill to pass because they don't want an abusive parent to abuse their kids for coming out as gay, bi, lesbian, or queer, even transgender. Even though I have a hard stance against kids not being transgender, we can have a debate whether or not we can bump that down to 16. But that's just a hard stance. I won't go below 16 because the kids' minds are still developing and it could be a phase or may not be a phase. My understanding of watching a lot of YouTube videos of people that transition, they pretty much knew at the age of 16. And there's some that may regret it down the road. And this is why I follow the tattoo laws. You gotta be 18 or older in order to get a tattoo because you're modifying your body. And I think taking hormones to suppress your developing body is also a form of abuse. And you find out that you don't want to, now your growth is stunted. So that's why I say 18. It's an arbitrary line, but that's where we declare that everyone's an adult for the most part. Now, if this bill does pass, this will be a win for parents' rights to have a say what happens with their kids. If this fails, I don't know what the status quo is, but as it goes, it's sad that you have to have a bill telling the school that the parents have a right to be involved in their kids' decision. I've seen tweets from certain politicians that says it's the school has the rights over the parents, which I disagree. Apparently, Georgia agrees with my stance that the parents have more say that happens within in the school district because they voted out that particular Democrat. It's kind of it's kind of a long read. It's kind of hard to digest. And I do hope this bill passes, even with the amendment, because we need to take back the power away from the schools and give it back to the parents. And I think the majority of parents out there, they care but don't care if their kid is gay or bi or lesbian or queer or transgender. But if you take away their right to know, you won't know how they're going to react. They could be 100% on board. And the fact that the school deems that they may be an abusive family if this gets out is taking away the parents' joy of supporting their kids. And I cannot stand for that because the people that are against this bill, it's taken away something that could be very joyful. The parents probably already know that their kids are already bi or lesbian or gay, bi, or queer. And if the schools take that away for that confirmation, we will never know if the parents going to be 100% on board of supportive. And I just can't agree with that. I just cannot agree with that because, the kids live there. There may be small circumstances where the parent don't want a queer child or a lesbian child or a gay child or a bi child that may abuse it. And I understand that concern, but we must not view every relationship as that. That's seeing bad in everything, and I want to see the positive in everything until proven otherwise. Leave a comment down below on what your thoughts are. I know this is a really long video, and hopefully you stayed to the end. If you did, smash the like and subscribe button on any and all platforms, or just the platform you're currently watching. But most importantly, have yourself a wonderful day, morning, or evening.